every dog bite case, there is a possible claim, but there are several things you have to show. One, you have to be able to identify the dog that actually, in this case, took the bite. If you know the dog belonged to an owner, the owner being a neighbor, you can then bring a claim against that homeowner who owned the dog. The claim would be against the homeowner, but the attempt would be to verify that there is insurance coverage for the homeowner and the homeowner's property, and a dog for this purpose would be considered to be part of the property. One of the things you look at in looking at a dog bite is to determine the propensity of the dog. Had the dog taken a bite out of someone else before? Had there been prior indications that the dog was a reckless, out of control dog? Was the dog on a leash, or was the dog allowed to move about unrestrained? And of course, witnesses. If there are any witnesses other than your husband, great. If not, you have him and the dog. I would like to know if the dog bite was reported to police, and if so, was there treatment by your husband at a medical care facility? Because all that becomes part of what's called damages. You see, in every injury case, dog bite, car accident, premises liability, which means a incident happened on someone's property and they're responsible for the property owner, which in this case would include the dog. You have to look at two main things. First, liability. Second, damages. Liability for a dog bite is established by a strict liability statute that we have in Florida that says if a dog bites, the homeowner is liable, but you have to verify who the homeowner is, the insurance, and what have you. Second, damages. To what extent has that caused a permanent injury to your husband? And are there neurological problems? Is there nerve damage? Was there a fracture? Is there scarring? All that will be taken into consideration. Here at the Gregory Law Firm, we will look at all that with you, go point by point as to the liability and damages parts of the dog liability statute, your husband's damages, and of course, don't forget, as a wife, as a spouse, you have what is called a loss of consortium claim. That means to whatever extent your spouse has been injured and has not been able to perform or present as he would normally in a marriage, whether that is with respect to intimacy, going to movies, outdoor activities, going to work, lost wages, medical bills, expenses, pharmaceutical costs, etc. To whatever extent he has suffered a loss, you may have a derivative claim as well. So do you have a claim? Yes. Are you going to pursue it? If you like our assistance, 904-722-2222. The Gregory Law Firm is here for you as your